Judge James Mize is a Superior Court judge in Sacramento, and he's had served as the presiding judge of the entire court system. He's taught over 100 courses and seminars to attorneys and judges in the areas of family law, domestic violence, and legal ethics. He will also answer such pressing questions as, can I appear in a Zoom court in my pajamas? And can I continue operating on my patient while at a Zoom hearing? So now let's hear from Judge Mize.
Well, first of all, thank you very much, Chris and Tom and the Renaissance Society for giving me the opportunity to speak to you all today. I'm really excited about doing this. I think we're going to have a lot of fun today, and hopefully we'll all learn a few things. One of the things I'm going to learn about is more technology. I know something about law, but fortunately I have Chris and Tom, and I've invited them to please interrupt as much as possible so that we can keep the technology running while we're doing the presentation today. So the first thing I'm going to do is get to my slideshow and see if this works. And this is the program Justice System 2021 and beyond. All right, so let's begin. First of all, before any time I give a presentation, I like to tell people what we're going to talk about. So the content today, I'm going to do just a little bit of a history of the justice system, and then we're going to spend most of the time about what the justice system is. What does it constitute? How does it fit in with our government, with the other two branches of the government? And then what we're doing now, particularly in light of the coronavirus, and what may change in the future, which goes to the concept of beyond. And we're going to have some fun. Since this is the baseball season, we're going to talk about these things with an analogy to baseball, because I think there is a good analogy there. And then finally, we're going to talk about what's different now and what we're going to see different in the coming years. I think you may recognize this gentleman. George basically said that the administration of justice, that's the justice system, that's what we're talking about now, is the firmest pillar of government. And that really all of the things with respect to the Declaration of Independence, to the Constitution, all of these things mention the concept of not just the president and the Congress, but also the justice system, with the understanding that the justice system is like significantly important to just the existence of our entire society.
Jim, I'm going to interrupt you 1 second.
Yes.
We have a little thing, there's a bar there. Can you close that? Yeah, perfect. Thank you. That's all I needed.
I saw that. Wasn't sure who else could see it. Thank you.
Yeah, that's fine. That's no problem.
No problem. And then, so it's in the Constitution of the United States about what the third branch can do and what it has to do in order to be able to make sure that we have justice in our society. So what I want to talk about is the first word I want to throw out is gravitas, because particularly in this area of Zoom, gravitas is something that may be lost, and we're going to be talking about that a couple of times during the course of this presentation. We often think about boldness or something that's really dignified, and we talk about that in terms of buildings. Those of you who have been to the Acropolis and have walked up to the Parthenon, remember what it was like if you were a warrior back in several thousand years ago, and thinking that you're going to fight Athens, and you walk up these stairs in the Acropolis, and then you see the Parthenon, and you immediately say, let's talk peace, because it is so bold, the building is so magnificent that it gives gravitas to everything that happens after that. Courthouses, likewise, are supposed to have that. There's supposed to be imposing structures, the Capitol buildings and courthouses, because it's trying to tell people that something important is happening. And we're going to get into that later when we start talking about Zooming. Question is going to be, can we Zoom and still not lose gravitas? All right. Now here's where I'm going to see if I can move to another section here. And Did I do that?
Yep, I think it looks good.
All
Just give it
right.
a second. We still have one bar in the middle. I don't know if you can click that off. Oh, it's gone now. Okay, you're good.
Hold on a second.
Oh, now we're seeing the black screen again. So
Okay.
I suggest you stop sharing and start again. Oh, no, now I'm seeing the Justice System 2021 and beyond. Yep.
See, I know this would happen. That's why we have these good people here to help me here. All right. And then
Okay, I'm seeing the importance of the impartial judiciary. Great, hide those. And
go.
give it 1 second. Very good.
All
Four
right.
ideals. Looks
All
good,
right.
Jim. You're
Thank
good.
you, Chris. First of all, there are 4 ideals that support the government of the United States of America. One, and the most important possibly, is the rule of law. We have something called the separation of powers. We have something called checks and balances. And of course, what I want to talk about a lot today is the concept of impartial courts, impartial judges. The rule of law, let's talk about that first. Law regulates everybody, and it should regulate everybody in the United States. And we're talking a lot about the rule of law now in the current situation in the election, et cetera, et cetera. And the concept of law is that everybody has the same rights. Everybody is equal, and that kings and dictators are no more important than person who is even homeless. Everybody is controlled by this rule of law. Since we are obviously in the middle of the baseball season, the playoffs, and I'm not going to talk about the sadness that anyone might feel today as opposed to yesterday, but basically there is an analogy between baseball and the Constitution and the rule of law in the United States. In this particular case, this gentleman just hit a home run, but the umpire said foul ball. And so I'm going to read these things, even though I normally would have my folks who I'm presenting this to read it. And the batter says, "What? I clearly hit it through center field and it's a home run. How can you say it's foul?" Umpire, "Too bad. That's my definition of a foul." Batter, "Show me where your definition is." Umpire, "Look, those are just my rules. I'm the umpire. Deal with it." King George was a bad umpire. And like a bad umpire, he based the rule of law not on any laws that were written, but on what he decided at any given time. He selected the judges who would make the decisions. And if you wanted to be a judge, you better do what King George said. That's different what we have. Instead of King George, we have the Constitution. And we have rules that are in the Constitution. And those rules we must all follow. For instance, allowing the courts to protect the rights. We have things like speedy jury trials and removing government and popular influences from the court. And that's going to be an important thing we're going to talk about later. And we also have a separation of powers. Some of this stuff is really basic, but it's not bad to be reminded of these things because I think we often forget, particularly when we have elections. There's 3 branches: government, the legislative, executive, and the judicial. We're going to talk mostly about the judicial today. The government powers are split. All 3 branches have power, and each of them have equal powers. And nobody can exercise a power granted to one of the other branches. So the executive cannot come into my court and say, "This is what you are going to decide in this case." King George cannot come in here. We also have something called checks and balances. And that is that if one branch doesn't agree with the other, it can take action against that decision. Now, there's going to be a joke coming up in a minute, but it goes so fast that I'm going to kind of have to give away the joke because then you'll get it a little bit better. A president, a senator, and a judge walk into a bar. And remember, we're talking about the 3 of them having checks and balances.
So, what are the real branches of power? Here's a hint. The president, senator, and a judge walk into a bar. Bartender looks up expectantly and asks, "Separate checks?" You see, our Constitution separates the federal government into 3 independent but overlapping branches: executive, legislative, and judicial. Here's an example of how it works. The legislative branch, Congress, is empowered to pass bills into laws. The executive branch, the president, can check Congress by vetoing a bill. Congress, in turn, can check the president by overriding a veto by a two-thirds vote. The judicial branch, in this case the Supreme Court, can check Congress and the president by declaring a law unconstitutional. And Congress, in turn, can change the Constitution through the amendment process. When it comes to the judicial branch, the Constitution stipulates that federal judges will be appointed by the executive and legislative branches rather than elected by American voters. Think about it. How can federal judges remain independent and impartial if they have to bow to political and popular pressures to get elected? John Marshall, the Supreme Court Justice from 1801 to 1835, said, "The greatest scourge an angry heaven ever inflicted upon an ungrateful and a sinning people was an ignorant, a corrupt, or a dependent judiciary."
Pretty important, pretty important. Impartial courts and judges. So we're going to talk about that now for a while. We have to, I will tell you, sometimes we use the words independent judges, and that means a lot to judges, but we found that that really doesn't ring well with the public. The public don't want judges to be independent. They want them to be impartial. We like to think of that as the same thing, but hopefully you'll see that the impartiality is so critical to what we do. Again, back to the analogy for umpires. Umpires have to only consider the rules. They can't be influenced by personal gain, prejudices, preferences, or beliefs. And that's going to be the very important slide that I'm going to come up with in a while. You can't call a game in baseball in favor of your team, like you can't call a swinging strike when the person held up the strike. And some of you know what I mean by that. In addition, they can't tell umpires how to make calls. So let's see what happens here. What happens if umpires know the rules or break them because of their own personal beliefs? Foul ball. Not again. Are you blind? That was totally a home run. And this time I have the official rules to prove it. The rules. It doesn't matter because it's my call. But you have to follow the rules. You just can't make calls for other reasons. Well, I got some pretty good reasons. In fact, I have about 2,000 green reasons that the visiting team gave me before the game. How is that fair? You get paid by the other team to make that dumb call. No matter how I play, you'll never let me score a run. And that leads us to probably the most important slide here when it comes to the concept of the impartial judiciary. If we talk about the legislative branch and the executive branch, the legislative meaning Congress or your local legislature, and the executive branch, which would be the president or your governor, they are put in there by political parties. They have special interests. People run for interests. The voters influence what they are. If they don't do what the voters want, they're out of office. And they have personal preferences that they have. In fact, you sometimes elect them because they have personal preferences. But what happens if we make it judges, the judicial system? Number one, you can't run from a political party as a judge. You can have a political party, but you can't say, I'm going to only represent Democrats or Republicans. Number two, you can't have special interest. A judge cannot be moved by special interest. Three, judges cannot be moved by what the voters might say. They can't, and that's important. And maybe even most important, if you have a personal preference, you cannot allow that to influence your decision. So the only thing left for the judge is the law, and of course the facts as applied to the law. I'd like to give this example right at this point. Let's assume you don't like drunk drivers, and there's a judge that is running for office, and she says, I hate drunk drivers so much that if I ever get a drunk driver in my court, I'm going to sentence them to 10 years in jail. And you think that's a great idea, so that you vote for that judge, and that judge takes office. From then on, that judge can never hear a drunk driving case because she has already indicated that how she's going to rule, and therefore she's not going to be a judge because she's ruling on personal preference and not the law. Very important slide.
Different words describe different people. But in the eyes of the law, there's one that fits us all.
And we talked about this before. Anybody who thinks that they are less than anybody else, that a president, a governor, a legislator is above us, we are all equal under the law. And the place where that equality occurs is in our court system. Again, we've got to fairly administer the law regardless of age, ethnicity, race, gender, disability, et cetera, et cetera. We have to be totally not influenced by public opinion. For instance, probably one of the most important cases in our nation's history, certainly the last 100 years, is Brown versus Board of Education. Even folks who don't know anything about law kind of know that Brown versus Board of Education was an important decision. But what I want to talk to you about is in 1954 in Kansas, if there were a vote for segregated versus integrated schools, people, probably 70% of folks in Kansas would have voted for segregated schools. And yet the court did not do that. The Supreme Court, by a unanimous vote, said that separate schools were unequal, inherently unequal, and therefore unconstitutional. The important point of this is that Brown versus Board of Education, which we all think of as being a great law today, would have been not decided in that direction if we took a vote of the people, because the people were in favor of segregated schools. And another real example of that, 11 years before that, was State Board of Education in West Virginia versus Barnett, when the Jehovah's Witnesses said, wait a minute, we can't salute the flag because that's against our religion. And the court decided that, no, that was unconstitutional to force a Jehovah's Witness to salute the flag in that particular manner. And Justice Robert Jackson said the very purpose of the Bill of Rights was to withdraw certain subjects from political controversy, place them beyond the reach of majorities and officials, and establish them as legal principles to be applied by the court. And Thomas Jefferson also said effectively the same thing. Every religious society has a right to determine itself the times for religious exercises and the objects proper for them according to their own particular tenets, and this right can never be safer than in their own hands, not in the hands of the government, but only in their own hands. Now, the role of judges. We don't write laws. We don't express our personal opinions in laws. I know that's going to sound a little unusual, but it's important to know that that's what we do. As umpires, we don't write the rule books. The rule books are written by the legislature and also by the executive branch. We only interpret and apply the legislation and other rulings by the higher court, whether we personally agree with them or not. Yes, I've made rulings in my life that I don't personally agree with, but I understood that the change in that law had to be by a legislator and not by me. So we apply the laws even if the public doesn't like the law. And the law is effective. It's not our job to say it is effective. It's the legislature's job to fix it. So again, I told you before, if you said that you were in favor of a certain thing and you wanted a judge to rule in that favor all the time, and that judge promised you that they would always rule on it in a certain way, regardless of the facts, that judge could never hear that case. Again, and also, obviously, judges are not allowed to accept personal gifts. I think there's a limit of 35 or 50 bucks or something like that. So you can receive a little citation saying you did a good job at the speech, but you can't accept money. This is an actual campaign.
Ever wonder why families never get a fair shake from the Michigan Supreme Court?
Lucille, where are my judges?
Just where they've always been, right in your pocket.
The judges probably are better judges than they were dancers, but again, this is what is going on in our country today, where there's a feeling that judges are not ruling on the law and on facts, but they're ruling because they are controlled by, in this case, maybe a governor or someone else who believes that they should not have any independence. I will say that there are a number of things that are happening to try to protect the courts, to enable them to continue to be impartial, in spite of the pressures to the contrary, in spite of the belief by many people that courts are not supposed to be impartial, but are supposed to follow their dictates of the people who voted them in. For instance, Sandra J. O'Connor and this PowerPoint are examples of things where we are trying to help people to understand and be vigilant that there are people who would like the judiciary not to be free, not to make decisions, so that to the extent that somebody would say that court made a decision that was wrong, I'm going to eliminate that court and I'm going to put people in judicial positions that will do the things that I want to happen. The founders, of course, of the United States realized that there had to be a place where popular or powerful was not going to prevail, but fairness would prevail. And that place where fairness prevails, where right prevails over power, where right prevails over money, would be in the courtroom. Now, things are kind of weird in different places. South Dakota actually had an initiative that did not pass, but it was supported by a lot of people that would say that if a judge made a decision that you disagreed with, you could be sued or sent to jail. The judge could. And you can imagine how independent those judges would be, how impartial those judges would be if they were faced with going to jail if they did something that a person disagreed with, particularly some person who was very wealthy. Again, umpires couldn't do their job if they were jailed for an unpopular belief, but a correct decision. And again, I won't mention last night's game. About in Sacramento, of you may remember that we had a Judge Lauren McMaster who had to make a decision whether civil unions between same-sex partners were allowable according to the Constitution. And when I talk to kids, I like to ask them a trick question. Lauren McMaster decided that same-sex partnerships, civil unions, were constitutional. So I asked them the question, what was Lauren McMaster's personal view of same-sex unions, civil unions? And the answer is, you don't know, because he was not asked to answer the question of whether he approved of civil unions, gay marriage. He was asked whether it was constitutional. And in fact, he decided that it was constitutional. Within literally days, a special interest group mounted a recall campaign for Judge Lauren McMaster, and then said if a higher court, meaning the Third District Court of Appeal, were to rule in that same direction, that they recalled those people as well. Again, would it be fair if umpires were fired by fans for an unpopular decision? Now, it doesn't mean that judges are impervious to being questioned. The Constitution has protections to handle disagreements with court decisions. For instance, you have the right to appeal any case. If you buy a pair of shoes that isn't working, you may have to sue to get your money back, but there's an instant way to get your money back. Whereas if I make a ruling that is wrong, you have the right to appeal. Everyone has the right to a first appeal. And again, going back to our sports analogy, it can be compared to instant replay. And the sharpest people of you will say, that's not an umpire, that's a referee in a football game. But we won't mention that. That's the best slide I could get for that. In addition, judges are currently subject to discipline. So if anyone makes a complaint to the Commission on Judicial Performance, they will look at what we did to see if we if we violated the rules of professional conduct.
Next case.
The People versus Martin White. Mr. White has been charged with...
Guilty. Next case.
But Your Honor, you haven't heard the charges yet.
Guilty. Next case. Guilty. 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 I've been prison. Guilty. Next case.
little drama there to show what it would be like if someone was not following the rule of law. Question we all have. We had this when we were kids, and we felt that we weren't being treated fair, but we feel that today. But how would you feel if someone made a ruling and didn't even listen to your case? It's certainly not something we want to do, and that's why we have to enforce the impartiality of judiciary for judges who will always hear the case before making a ruling. And this is for everybody. And these are the people who are defending our rights. Now here I'm going to call upon Chris again to see if I can move to my other slideshow. And we will see if this works.
You got it. That's up. So
Wow.
just remove that. Make sure those bars go away. And there we go. We're good.
All right. Well, again, Chris is a great teacher. I'm a slow learner, but we got there. So let's talk about then where we go from here. We talked about a little bit of the history and the essence of judicial conduct, which it has to be impartial. First of all, let's talk about this. Any changes that are going to happen in the judicial system is really, really slow. There are a number of people who are trying to make changes in the judicial system, it talks in terms of decades and centuries and not in days. But the coronavirus came on us this year. And as a result of that, we had to make major changes instantly. Courts were closed, totally closed. And yet, even though they were closed for several days, actually even several weeks in some places, we still had to do some things. Criminals had to be tried. Domestic violence had to be restrained. If we did not have the courts open and they said, I'm sorry, we're not open to you, what would happen? Well, people would then say, fine, if you can't handle my case, then I'll handle it myself. And then we're going back to anarchy at that point. The California Supreme Court made special orders during the coronavirus, saying that we can hear things on Zoom. We can do things with no trial appearances. We can eliminate people from coming into the court except those people who actually had cases. And as a result of that, we did okay, but we got to talk a little bit about that because this transition to Zoom and the transition to the coronavirus situation in the courts has raised lots of new questions that we have to talk about. So I'd like to talk about what happens maybe in 2022. And I guess I'm being a little optimistic that maybe the virus will be over then. Well, first of all, let me tell you, when we started going to Zoom, attorneys and litigants loved it. They didn't have to travel to the court anymore. Domestic violence perpetrators did not have to face the perpetrator. And I said him here, it could be him or her. And the experts could be brought in at much less expensive because it was cheaper to have them Zoom in from New York than to fly them out here from New York. However, we're losing some credibility when we're on Zoom. I've done 1,000 Zoom hearings already. Well, there are a couple of times where I've been in a Zoom hearing and I asked the person a question and they stopped and they looked to their side and they obviously were coached by somebody else in the room who I couldn't see. And then they turned back to me and said yes or no or whatever that other person told them. So I don't see the whole room, I just see them. Sometimes I'm talking about major custody battles. And then I find out that the children are in the room listening to it, whereas they would never be able to do that in a courtroom. So it's really not good at all. And then when the lead-in that we had beforehand, frankly, if we have people who are literally driving in their car in their pajamas, eating a sandwich, and saying, Judge, what's going on in that court? I don't agree with what you're doing now. In this case, where did gravitas go? Where did the Acropolis go? Where did the Parthenon go when you have people in their pajamas in a car driving, eating a sandwich? Do they have respect for what is being said in the courtroom or what the other side is saying? Their attention at that point is about zero. Some of them are even driving, and we try to get them off the road and say, please get off the road first. Their gravitas is zero. They don't have much respect for what's going on in the court. They didn't have to walk up the stairs, up the Acropolis stairs to the Parthenon. Instead, they just turned on their iPhone in their car. Wi-Fi and technology, as it is today, it's working real good today. But I will tell you, every time I've had any day with a Zoom hearing, one or two of the people can't get on, don't know what they're doing, or their Wi-Fi gives out, or it gets it starts to pixelate. There are a number of things that can happen. So the Wi-Fi isn't that good. However, how do we compare that Zooming with people with courts that are in session when they have the virus? For instance, in court now, we are doing a hybrid. We're doing some hearings on Zoom and we're doing some hearings in person. But if they're in person, everybody's wearing masks. Well, I want to tell you something. When a person is wearing a mask, you'd be surprised how difficult it is for a judge to describe credibility. And something that I like to tell people, sometimes the credibility is not of the person speaking, but the person will say something on the stand, and then I look at the other side, their opposition. How do they react to the thing that is being said on the witness stand? That is incredibly helpful to me to determine the credibility, not necessarily the witness, but the credibility of the person who's sitting at counsel table. So if I had to pick an order of what I need to make a good decision, I would say the last thing I want is in-person hearing with masks on, because while that's nice for some things, I can't tell credibility. Then I would do Zooming without masks, because then I can at least do Zooming. I can at least kind of judge credibility, but I can't judge the credibility I can't judge whether somebody else is in the room giving them their answers. So what I would want is I want everything to go back to in-person without masks, which is going to be disappointing to those people, because in fact, is there an access to justice issue with Zooming? Yes, no question about it. It's cheaper for people to come to court. It's better for people who aren't going to lose a day's pay by having to come to court and wait around for a day and lose their day of labor. It's how about the people with kids? What about who's going to care for my kids while I'm coming to your court? I can just do that on Zoom, put the kids in the back room, give them some Cheerios and an iPad, and they're good for a couple of hours while I'm in your court. However, what about the quality of justice? You're going to see why I showed this scene in a minute. The judges have a hard time judging when, in fact, we can't see what's going on in the room. Judges don't respect the dignity of the court. There's coaching in the Zoom rooms, and here we go. I cannot tell you already in the last 6 or 7 months that I've been in court, how many people have come onto their Zoom, not wearing their shirt, and then maybe buttoning up their shirt, or worse, and I'm not going to talk about the worse, but you can get the idea from the picture that I have there about how bad it can get on Zoom when people think they are not really in a dignified Acropolis Parthenon courtroom, but in fact, they're just sitting at home in their casuals. So what are the answers? Well, we got to continue to experiment, compromise, hopefully get better IT. Before the virus hit, when anybody asked to appear in Zoom, which we had the ability to do even 3 years ago and before, I almost never let it happen. Now, probably I'll let it happen more often. Which kinds of people? Probably for settlement conferences, we used to require people to be there. Not probably anymore. We don't necessarily need people to come because settlement conferences don't have that same kind of necessity of judging credibility because the people are trying to settle. Minor witnesses, the person that's just going to say that maybe, yes, I was at the scene and yeah, I heard a ruckus. I wasn't sure what was going on, but I didn't recognize anybody. But yes, there was some fighting going on or something. Experts, maybe the New York expert doesn't have to be in front of me because the expert's credibility is not important as how smart that expert is and how convincing she is to me regarding what it is that they're trying to talk about. So there is some change that maybe can be made using Zoom. So where are we going from here? First of all, I would think that in 10 years, we're going to get better IT. We're going to have people like Chris and Tom getting together and making things work really, really well. I would like to, if I had a Zoom hearing, I'd like to be able to scan the room. I'd like to be able to have 3D close-ups of the witness so I can see them the way I would in my courtroom. And I'd like to observe them and anybody else in the room, make sure there's no kids there and to make sure there's nobody else giving them signs. But when we do that, are we going to lose gravitas? Are we going to lose the Acropolis effect, as I put it here? I'm a little bit concerned about that. How do we maintain the dignity even when we're only on Zoom or when we do that principally? Well, let me talk to you about some things that are happening even today. And this is the gentleman just after he got off the space flight. Right now, I'm involved in a project in the state of California where we are putting together machines for translating. Somebody speaks into a machine in one language and it comes out in another language so that they can make fast translations. And again, those of you who are Star Trek fans, you know what a universal translator is. You speak in one language, but it comes out in the language of whoever you're speaking to. That is something that we're working on now. It is going to be in the future. It's not right now scheduled to be in courtrooms, but it is scheduled to be certainly outside in the front offices where somebody comes in speaking an unusual language and the clerk can talk to them and say, what are you here for? And the person can speak in their language. I'm here to file a domestic violence action against my husband, and that will be translated into English. That's happening right now. We're developing that right now, and we'll probably develop it faster now that the coronavirus has made us move fast with everything. How about court reporting? Well, right now, court reporters are incredible. They do an incredible job, particularly when people speak at the same time a little bit. They stop us sometimes and they say, wait a minute, got to slow down. But in the future, we can have 20 microphones set on every possible place in the courtroom, and 5 people can be speaking at once, and a AI can then find out who's at what time and can give us a graphic of who's speaking and what they're saying, even though they're speaking over each other. However, we're talking about interpreters and we're talking about court reporters who would be displaced by that. We want them to have jobs. So do we need retraining? Is there something else that they can do when that happens? Is this going to happen tomorrow? No. Is it going to happen in the next 5 or 10 years? No. Languages are going to develop probably with universal translators in the front desks, the front offices, probably not in court for a while, in court reporting, maybe not for a long time. But someday, 100 years from now, of course, we know what's going to be there. In the early 21st century, all cases were oral. Words only were used. Hearings were only done by words. And if those of you who have been in court, you were instructed by a judge speaking up there and droning on and on. I've droned on, so I blame myself too, about what the law was and what you had to do. But even in this century, attorneys have introduced graphics and videos and simulations to be able to kind of demonstrate how the accident occurred, what did it look like, et cetera, et cetera. So we're using that even today, at least certainly attorneys are. I'm going to give you an example of what I did 15 years ago in order to try to assist people to be more attentive. Anybody who's in my court, if they're sleeping, they aren't learning anything. So this is what I used to introduce my court staff. This is my bailiff. I said, this is what she did, and this is who she was. Then this is my clerk, and this is what she did. And she places witnesses under oath, again, those things. And here's my court reporter, Sunday, who kept a verbatim transcript, including a real-time record so I could read it. And here she was. And then, of course, I had to introduce myself as the judge. And here I am. I controlled the proceedings. I ruled on evidence. And then I made sure, going back to what we talked about earlier, that both sides have a fair opportunity to present their case. Now, when I did this, I also said, these are PowerPoint slides. And I try to say, why are we using PowerPoint slides? Well, because those of you who are educators know that everybody has a different learning method. Some people learn better by hearing. Some people learn better by seeing. Some people by touching. Many of us learn better by doing. And as a result of that, we're using more visual aids now. However, we want to make sure that those visual aids do not detract from the serious and important work we are doing. Again, gravitas, which I mentioned earlier a couple times. I'm going to give you a little bit of an example of how this might be able to be brought into effect in court in your jury instruction on direct and circumstantial evidence. I used this exact PowerPoint or these exact PowerPoints 10 and 15 years ago in my trials. I'm going to tell you, you're in front of you've just had the evidence presented, and you're going to get the decision and go into the jury room with your jury. And I've got to tell you what direct evidence and circumstantial evidence are. So here's what I say to you. Direct evidence is evidence which, if true, establishes a fact without the need of an inference. And by the way, circumstantial evidence is evidence of another fact or group of facts from which you may conclude the truth of that fact in question. And in fact, both direct and circumstantial evidence are acceptable types of evidence to prove or disapprove the elements of a charge, and neither is necessarily more reliable than the other. So you all got it, you all understand it. Now go in the jury room and make your decision. However, what I did is a little bit different. I started with the definition, evidence which, if true, establishes a fact without the need of an inference. And then I used a little graphic. I said, Mom sees a child eating a cake. From that, she concludes that the child ate a cake. That is direct evidence. Circumstantial evidence, and I've said, is evidence of a group of facts from which you may conclude. I say, Mom walks into a room and sees a jagged hunk off of a piece of cake. She sees fingerprints on the wall and in the hallway. She sees crumbs in the hall, and she sees crumbs on the face of her 4-year-old. From those group of facts, she can infer that the child ate a cake. I think that graphic is more clear and makes it more obvious as to what they're supposed to conclude. So in conclusion, basically, I would say that one, the preamble of the Constitution says, we the people of the United States want to secure the blessing of liberties to ourselves and our posterity. So 250 years ago, the Constitution was written not just for that day, but was written for us today, as long as we understand it, as long as, in the words of Benjamin Franklin, it's a republic, if we can keep it. And we can only keep it through the posterity if we do things like we're doing now. This is a never-ending process. And it's secured by folks like you in the Renaissance Society who are constantly searching and inquiring and listening and learning. So I want to thank you. I want to thank you today for the privilege of speaking to you. And I thank you for being you. Specifically, as long as there are folks like the Renaissance Society around, the future, whatever it is, I'm sure will be good for all of us. So thank you very much for the opportunity to present to you. And now I turn it over to Chris or Tom or someone for questions.
Great. Just hit that escape button and stop your sharing. There you go.
Did I do that right?
Perfect.
Great job. Hi, Jim. We've got a number of questions lined up here from the audience, so we'll just jump right into them if it's okay.
Oh, absolutely.
All right. So the first question that one of the audience had mentioned is, what do you feel about term limits for judges, especially Supreme Court judges, and what issues lead you to your conclusion or opinion?
Again, I'm going to say that all of these questions are going to be great, and that's a good one. And one of the things that the PowerPoint demonstrated was federal courts, federal judges. In fact, state judges like myself, I'm a Superior Court judge in and for the county of for the state of California, in and for the county of Sacramento. We do have term limits. Well, we don't have term limits. We have limited terms. Our terms are 6 years, and then we have to be reelected. So therefore, if somebody doesn't like what I'm doing, they can run against me, or they can vote me out and vote somebody else in, and then I'm gone. I've stood for election 3 times for 6-year terms and was reelected each time. Now, I will tell you that a little bit more than maybe your folks wanted to know, but for the most part, judges in large counties go for reelection every 6 years, and most of the time they are not challenged. Most of the time, we hope, because they're doing a decent job, and if they're doing a decent job, they should stay in office. Term limits for federal judges, okay, the answer is yes and no, because the good news about term limits is that we get rid of the rascals, the ones who aren't doing a good job, the ones who are politically motivated. The bad news about that is if there are term limits, if there were term limits and people could be voted out of office real quickly, then Brown versus Board of Education may never have been decided, because the judge in Brown versus Board of Education was a federal judge. He knew at the time that he would not be voted out of office because he had lifetime tenure. So he was willing to make the decision that would be incredibly unpopular to 70% of the constituents in his district. And in fact, another little known fact about it is that he was hounded in his home. People criticized him. They subjected him to a lot of abuse because of the decision he made. We say, well, but that was the right decision. Well, at that place in time, it was not right. So at that point in time, I'm glad that he had tenure forever, because he didn't have to worry about looking over his shoulder to make the right decision. I don't think it's an either or. I think we have to decide, would I like to have been appointed for life? Yeah, no question about it. But I'm getting towards the end of my tenure. So frankly, as we all say, in our last 6-year term, and I've just been elected for the next 6 years, not sure I'm going to make it. So we call this last 6 years in a state term our federal term, because it says it's the equivalent to the rest of my career.
You're going to make it. Don't worry.
I hope so.
A very insightful answer. Thank you so much on that. So the next question comes from Marcia. Should Justice Barrett recuse herself on abortion issues, since she has already stated her personal beliefs on that?
You know, again, we're going to be talking a lot about the federal court and the Supreme Court of the United States. And I know that there's maybe another question that's going to be even more direct on that point. And I'm going to kind of get to my conclusion already about a question that I thought was going to come up. And that is this, that there are times in our history where we believe that the court, particularly the Supreme Court, may be too political. On my level, as a trial judge, I don't get to make decisions that are that bold and wonderful. I have very modest decisions that I make down here. They may be very consequential to the parties that are in front of me, but they aren't changing policy like the Supreme Court of the United States of America or the Supreme Court of the State of California is. So that what I would kind of say is twofold. Number one, I'd like to go back in history a little bit. In 1933, 34, 35, our President Roosevelt wanted to pack the court. Why? Because he thought it was too political. And yet in 1954, the Supreme Court made an incredibly wonderful decision in Brown versus Board of Education that segregation was wrong in segregated schools. So that my feeling in going back to maybe feeling that the court may be too political now, as opposed to, and again, we're just picking at this time on maybe Miss Justice Barrett, that I'm hoping that this is a pendulum, that it goes back and forth, that there are times where we are not happy with the politicization of the courts. And then there's a movement of everybody, no, let's not appoint political people. Let's appoint people who are less political, who have a reputation for being just ruling on the law. And let me give one more example of that. Obviously, everybody knows about the battle now between our former president and the current president, the Democrats versus Republicans. And my wife and I have thought, gee, how terrible this is, et cetera. Well, I also happen to be reading Alexander Hamilton. I'm almost finished with it. And those of you who have read it, not seen the movie, the play is wonderful. So see that, but read the book also. And if you look back, the battle between Thomas Jefferson and Alexander Hamilton was vicious. It was nasty. It was ugly. It was terrible. And yet after that, we had Abraham Lincoln's. We had people who were bold and spirited. We had people who worked together to vote for things that improved the country's lot. If there were people in Thomas Jefferson in time who thought that the republic was over because of the nastiness, and yet there was an evolution. So the long answer to that short question is this evolutionary? Is this pendulum where we will swing back? I'm hoping, because I have a faith in democracy, if we can keep it, that this is a pendulum and that we will swing back someday to something that makes us feel that the courts, particularly the highest courts, are more independent and ruling more on the law and not based upon political preferences.
Great. Well, we are certainly going to be looking at which way the pendulum's swinging soon. I guarantee you that. So I think we have room for maybe one or two more questions here. Let's see. When discussing impartiality, sort of getting back to impartiality, aren't there gray areas in the law where judges' personal opinions do come into play?
Okay, and all these are just incredible questions. I would expect nothing less from the Renaissance Society. To say that a judge doesn't have personal opinions would be obviously untrue. It'd be unrealistic. However, I teach courses to judges, and one of the things we talk about is implicit bias. For those of you who are unfamiliar with that term, that means a bias that exists within us that we don't even notice. And basically, I have tests that I give, and basically after I get done with the test and the judges that are before me, it demonstrates that all judges have biases. And they're shocked at that. They don't want to hear that because they're judges, so they don't have biases. So I really like to say there are only two kinds of judges. There are good judges, and good judges are defined as those judges who know that they have implicit biases and work to try to make sure that those are not going to influence their decisions. The other type of judges are called bad judges, and those are judges who deny that they have any biases or that they have any implicit biases, so therefore they're not working on them. So that's again, the more longer answer to the question of, are there biases? Of course, but good judges work very, very hard to try to make sure that they're not allowing their personal biases to affect the decision that they make. Yeah. And I hope that the Supreme Courts will do that too. And maybe they will, and many of them do.
Realistic answer. Thank you on that. One more last one. I was hoping we'd get to this one. Let's see. What do you consider? What's that?
Ask an easy one.
Okay, here's an easy one. What do you consider the most important or influential Supreme Court decision, and why?
The most influential?
Yep.
Oh my. Well, there were many influential decisions, some of them positive, some negative. Obviously, I believe in Brown versus Board of Education as being one of the most influential in the history of our country, and certainly the last 100 years, as saying that no, segregation is not appropriate, and it's not appropriate to take a section of our society and say, no, we can't have those people have the same rights as everybody else. Right. But on the flip side of that, I would say that Bush versus Gore, 2000, was a influential decision, and not necessarily an appropriate one, because that's where a conservative Supreme Court, which is in favor of states' rights, decided that they would take over and say that, no, we're going to apply federal law to the election that was going on in California, in Florida, excuse me, and that they would rule on whether the hanging Chad should be counted, as opposed to them saying, hey, we're in favor of states' rights. We're in favor of them doing something that where they determine who the electors are in that county. It's very significant in this time when we're talking about electors and who's going to elect the people from the various counties. So that's really critically important. I think the decision that made corporations people for certain reasons really was problematic in several ways, because we have something like PG&E being responsible for many deaths, but as a corporation, they can't be tried and put in jail. They can be fined, whereas if a person did what PG&E did, they could be accused or sentenced to jail for involuntary manslaughter minimum, if not some degree of murder. So as a result of that, we have a number of them that are incredibly important, that have affected and will continue to affect the lives of all of us. And we will have another 2 or 3 or 4 coming up, very important, in the next session of the Supreme Court.
That's right. Well, Jim, and we really appreciate a fantastic presentation. We appreciate that you've come and spent your time with us today. And as you know, the Renaissance Society is providing you with a free membership to our society over the next year. So you can appreciate and enjoy the classes and the opportunities that we have. So I'm going to hand this back over to Chris, and he's going to close out the program today. Thank you again for a fantastic presentation.
Well, thank you again, both Chris and Tom, and thank you, Renaissance Society, for keeping awake during most of my presentation. Love it.
Well, keeping awake wasn't a problem, that's for sure. Really enjoyed it. We do want to thank you, and if you can accept the honorary membership to the Renaissance Society, not sure if that exceeds any limits for you, but we also give a donation to the Seth Nelson Student Emergency Grant Fund for each of our speakers. Just a reminder to everybody that today's presentation was recorded. You can view it 2 separate ways, either by going to the Renaissance Society Forum channel on YouTube, or visit the Renaissance website and click through to see it there. We got a really great program lined up for next Friday. It's going to be an extra long one, an hour and a half, because we have a lot of speakers. So we've got fantastic gold medalist swimmers. This forum is going to feature 5 Olympic gold medalist swimmers, including Mark Spitz from the Sacramento region. This will be a roundtable discussion of the experiences of being world record holders, what it took to have such focus, what they had to give up for their careers, and how they handled transitioning to post-Olympic civilian life. Our very capable 4-time Emmy Award-winning Beth Ruyak, formerly from Capital Public Radio, will be moderating the discussion. So we know you're going to really enjoy it. So please stay tuned, come in next Friday, and thank you all for joining us. We'll see you then.